Hi, everybody. Welcome to another lesson in policing. This one is policing the law, and this is part one of a two-part lesson. I think that you'll find that policing and the law and legal issues tend to be among the material that students find both the most interesting but also the most challenging. So I cut this lesson into two different parts. We'll get through about half of it now, and then we'll do the other half. I made a recording for the second half as well. Right? So sit back, relax, and enjoy. Okay. So this particular lesson, we're going to explain the concept of judicial review and describe how it applies to the police. Listen, describe various constitutional amendments that specifically impact policing. Discuss case law relevant to the exclusionary rule. Describe standards of proof. Listen, describe exceptions to the Fourth Amendment. Explain custodial interrogation and Miranda, and then explain eyewitness identification procedures. For this first part of the lesson, we will get up to just about here, standards of proof. Okay, so let's move along. So the first thing is that you need to understand is this concept of judicial review. What exactly is it? How does it affect the police? Well, police must adhere to the U.S. Constitution and applicable law as agents of the government. However, the interpretation of law it changes over time, and the body that's responsible for interpreting the law in the United States is the Supreme Court. So, how do we know what constitutional policing is? And we know that based off of what courts decide, court decisions. And this is why it's always important to follow the law in the streets also, because when citizens and police interact, and maybe they have arguments over the law, interpretation of the law, you know, the citizens are not designed to win those battles. Citizens can beat the police, can beat the system in the court system, and that's what it's designed to do. Courts have routinely changed police policies and procedures over the last 100 years through a process known as judicial review, and you'll see that's very applicable to criminal justice. Judicial review, we can think of that as the process by which actions of the police in areas specifically as they relate to search and seizure, arrests, custodial interrogations, how they're reviewed by the court system to ensure their constitutionality. And over time, particularly in the 1960s, the U.S. Supreme Court made quite a few decisions that really changed the landscape of policing. All right. So these are known as landmark cases, and landmark cases are cases that set some kind of legal precedent that didn't exist before. And there are a number of landmark cases within and outside of criminal justice. You can think of Brown v. Board of Education as a landmark case, Roe v. Wade as a landmark case. In criminal justice, you could think of cases like Miranda v. Arizona, Terry v. Ohio, Mapp v. Ohio, Escobedo v. Illinois, among the many cases that are considered landmark cases. Roper v. Simmons. So many of these decisions that are made by the courts try to strike a balance between individual liberty and collective security. Police and our security apparatus being responsible for the security of the citizens and upholding their rights and the Constitution at the same time. Very difficult balance. So this requires a sort of basic understanding of the constitutional amendments that apply to criminal justice, particularly. And I know that most students have exposure to this both in Criminal Justice 101 as well as constitutional law, but it's important to go over it here to sort of set the backdrop and the stage for what comes next. So when we think about the First Amendment, you think about those related to freedom of speech, religion, press, right to peaceably assemble. I put an asterisk, next to those rights that are considered more the domain of sort of public safety agencies like the police. Like police are responsible for upholding freedom of speech and the right to protest. They have to allow individuals to be within sight and sound of what it is they're protesting. And often protest groups have counter protest groups, and those counter protesters have to be within sight and sound of those protesters. And the police have to remain neutral in this. Remember, they have to adhere to the law and the Constitution. That's where their loyalty is. It's not to any particular group, not to a political ideology. It's to the Constitution and the law. And in order to do what they have to do is uphold the First Amendment for individuals. They have to remain neutral. The Fourth Amendment is really the big one when it comes to policing, and because police deal with primarily searches and seizures and arrests, they are the government agencies that are responsible for doing that, taking away people's freedom, at least temporarily. So Fourth Amendment protects against, this is very important, it protects against unreasonable searches and seizures. And I underline the word unreasonable for a reason, and because that is a word that has gone, much case law is behind that. What is reasonable? What is unreasonable? When is something reasonable? And to who is it reasonable to? So that's something that is often debatable. But the Fourth Amendment does not protect against all searches and seizures. It protects against unreasonable searches and seizures. What exactly does that mean? And how does it apply to the police? And also, the Fourth Amendment requires that warrants are issued upon probable cause, as well as arrests. All right, warrants are issued upon probable cause, and probable cause is a really important term. I'm going to come back to it in a little bit, but it's incredibly important legal term that the police have to deal with. All right, it's a standard of proof. I'll talk about that in a little bit. The Fifth Amendment, we hear about the Fifth Amendment. People say, I'll plead the Fifth. I plead the Fifth. It means not to say anything, right? So the Fifth Amendment gives you a right to a grand jury if you've been arrested for a felony. Protection against double jeopardy, being tried twice for the same crime. It doesn't mean you can't be civilly held civilly liable or in a different jurisdiction, but tried twice for the same crime. You get arrested for, God forbid, manslaughter, and you're found not guilty. New York State can't turn around and charge you with manslaughter again, right? So that's protection against double jeopardy. If there's a mistrial, it's a different story. If it's a federal charge, that's a different story. A civil charge, like you're being sued by the family, that's a different story. But you can't be tried twice for the same crime. You can't be compelled to testify against yourself, and that's where we get the idea of, I plead the Fifth. I don't want to say anything. Due process, you are entitled to constitutionally guaranteed and entitled to certain rules and regulations of the system. The Sixth Amendment, speedy public trial, impartial jury, confronted by witnesses and aware of the accusations. That's a big one right there. And you have to be made aware of what you're being accused of, both by the police as well as by the courts at arraignment. They're required to tell you what you're being charged with. But in addition to that, confronted by witnesses, and this is a big sticking point in our criminal justice system. And a lot of victim advocates have a big problem with this. Remember, the burden of proof in our system of government, in our system of justice, is on the prosecutor, the prosecution, the government. All right, they have the burden of proof. So it's not up to the person who's arrested to disprove anything. It's up to the prosecution to prove something. So if somebody alleges that you were engaged in a crime, it's up to them, the witnesses. It's up to the victim. It's up to the government to prove that. And you think about really high-profile and terrible cases like sex assault, murder, cases like that, kidnapping, where the victim has to, or the victim's family or victim members, witnesses have to testify, and they feel like they're being re-victimized because of the criminal justice system or the court system. Well, our Constitution guarantees the rights of the accused, all right, confronted by witnesses and aware of the accusations made against you. You have a right to an attorney. When you think of the Fifth and the Sixth Amendment, often people think of Miranda, the Miranda v. Arizona case, because the Miranda v. Arizona case did not make it so that you have new rights. It just made it so that the police had to make you aware of those rights when you were arrested, when you were under arrest and you were being interrogated. Okay, arrest and interrogation. And I'll talk about that during the second part of the lesson. All right, so the Eighth Amendment, no excessive bail, fines, no cruel and unusual punishment. Those deal more with the back end of the criminal justice process for the most part. And the 14th Amendment, basically, which is a Reconstruction Amendment after the Civil War, states can't pass laws that are deprive you of due process and equal justice of law, throughout the 50 states. So, you have a Fourth Amendment right in New York, New Jersey, Connecticut, Florida, California, Texas, Idaho, wherever. Okay. All right. So that's just the backdrop. Now we think about this next idea, which is called the exclusionary rule. So this sets the stage for the judicial intervention in the criminal justice system as it relates to the police. The exclusionary rule is not something that's in the U.S. Constitution. Rather, it's an interpretation of how the Constitution applies to law and the everyday happenings of citizens. This is known as case law. It's decided by courts rather than by statutory law. Statutory law are laws that are passed by people we elect. Murder is illegal. Drug possession is illegal. Criminal possession of a weapon is illegal. Smoking marijuana in public is illegal. Drinking in public is illegal. Those are laws that are passed by people we elect. Those are statutory laws. Case laws are laws that are decided by courts, the courts, and handed down through like this idea of judicial review. So the first case that establishes what's called the exclusionary rule comes from the Weeks v. United States case in 1914. And the U.S. Supreme Court here says that evidence that is seized by the federal government, and this is very important, by the federal government in violation of the Fourth Amendment cannot be used in court against the defendant. What that means is, remember the Fourth Amendment is you have a right against unreasonable searches and seizures. So if the federal government searches and seizes you prior to 1914, or really after 1914, Federal government, FBI, ATF, you have U.S. Marshals, Drug Enforcement Administration, TS, whatever federal agency takes evidence against you unlawfully, that evidence should be suppressed, thrown out. Okay, and anything that comes from that initial unlawful arrest, seizure, is considered fruit of the poisonous tree. Fruit of the poisonous tree. So I'll give you an example of how this applies at the state level in just a second. But the bottom line here is courts, the U.S. Supreme Court establishes the exclusionary rule. That which is unlawfully obtained by the federal government has to be suppressed. Now, if you think back to earlier in the semester, I talk a lot about federalism and how the U.S. government is broken up into, it's not just disaggregated between, there's judicial branch, executive branch, and legislative branch, sure. But I think more importantly, there are layers of government and layers of authority, federal, state, and local layers, right? So applies at the federal level, not at the state level, not yet at least. Okay. So the Mapp v. Ohio case, which is a landmark case as it relates to criminal justice and policing for sure, establishes that the U.S. Supreme Court established that the exclusionary rule applies to all state governments. And since local governments, like cities, towns, villages, and counties, are under the domain and auspices of the state, the exclusionary rule applies to all police departments, all law enforcement agencies throughout the United States, because policing is primarily a local entity. It's controlled by local jurisdictions and operated by local jurisdictions, but it's overseen at the state level. And the Mapp v. Ohio case, the Supreme Court said that this rule, the exclusionary rule, applies to all cases involving, state level and local and jurisdictions like law enforcement agencies. The idea was to sort of control police misconduct and control police behavior through suppression. So if the police enter into somebody's home unlawfully and they gather evidence, they can't then use that evidence against the individual. It has to be excluded. It has to be thrown out. So this was established in 1961. This has gone through quite a bit of changes over the last 50, 60 years, but still the fundamental ideas about the exclusionary rule still change. And the impact of the exclusionary rule is, some people really saw it as judicial overreach, like the courts moving too far into what police should be doing. And some people view that as allowing individuals to get off on a technicality. Later on, the U.S. Supreme Court carved out what is known as the good faith exception in the U.S. versus Leon case from 1984. And there's been other cases since, and you'll address those in the constitutional law. But just to get a sense, exclusionary rule means that when something is obtained unlawfully by the police, everything that comes from that has to be suppressed, thrown out, excluded, cannot be used against you. All right? There are exceptions, but that's the general rule. Okay. Next concept here that you have to have a good sense of is this idea of standards of proof. Okay? And standards of proof, this is, incredibly important. Incredibly important. So standards of proof is what is the legally sufficient evidence that the government needs to do something against you? All right. What is the legally sufficient evidence? Okay. Is it probable cause? Is it proof beyond a reasonable doubt? Is it reasonable suspicion? So the highest legally sufficient evidence generally in the law is considered proof beyond a reasonable doubt. And that is the necessary and appropriate amount of evidence that the government needs against you to have you convicted of a crime. Right? That's the highest standard in the law, beyond a reasonable doubt. People have put different percentages on it, but you could think of it as really like, almost absolute certainty, close to it. So below that would be a medium amount. That's preponderance of the evidence. Preponderance of the evidence is like more than 50%. And that's the amount of evidence necessary for you to be held liable in a civil case, preponderance of the evidence. You're being sued. You're suing somebody. You got into a vehicle collision. You slipped and you fell and you're suing the city. Right? Preponderance of the evidence. It's not beyond a reasonable doubt. It's preponderance. It's mostly correct. Below that is what you would consider a moderate amount of evidence. A moderate amount of evidence, which probable cause falls under what you consider a moderate amount of evidence. That's the amount of evidence necessary for you to be arrested, for the government to obtain a warrant. Okay, and that's in the Constitution, in the Fourth Amendment. In the Fourth Amendment of the Constitution, probable cause is the necessary amount of evidence in order to arrest you, get a warrant, conduct a search. Right? I'm going to stop right there, and we'll continue with this on part two in just a second.